Hi everyone, welcome to the fourth episode of the Data Protectors podcast. My name is Meshach Masibo and I'll be your host for this episode. For those who did not tune into the first three episodes, the goal of this podcast series is to offer guidance to SMEs and small organizations on how to comply with the Data Protection Act 2019. Today, we are coming to you with a thrilling and exciting episode that we've been developing to help our audience, first, to understand what a cross-border data transfer is, secondly, the related legal obligations by SMEs and small organizations, and third, how to comply with these obligations. According to the Data Protection Act, a data controller or data processor may transfer personal data to another country only when it has given proof to the data commissioner that the data will be transferred securely to a place with equal or stronger data protection laws. However, there are also certain situations where data can be transferred without notifying the data commissioner. We will discuss this and more in this episode. But before that, let's have a look at the partners behind this podcast. Have you heard of the African Union European Union Digital for Development Hub? In a nutshell, it is a project that aims to increase cooperation in the digital field between Africa and Europe, and it is implemented by 8 partner organizations including JZ and Kictanet. Did you know that our Data Protection Act in Kenya was inspired by the European one, which is called the GDPR? Therefore, data protection is an exciting and promising field for Africa and Europe to collaborate on, which is how this podcast came to life. We'll share more information about the AU-EU D4D Hub project and the partners as we go along, but let's start hearing from our guests. For this episode, we are privileged to have 2 guest speakers, John Walubengo and Simon. I will not pretend to pronounce the second one, and will be moderated by Lemmy. They'll serve as our guides for this episode.
Welcome to the show. My name is Lemmy. My work as a practicing lawyer in this lovely city of Nairobi. So globalization and technology have changed the way we run our businesses and manage our organizations. In today's world, we increasingly rely on technology to run our businesses, and where technology is not our main business, it's a platform that we use to carry out our business and organizational activities. With globalization, the world is increasingly interconnected, and a lot of transactions transcend the borders between countries. For instance, Tala Mobile is originally based in California in the United States, but offers some digital lending services to Kenyans. In the same way, a lot of small and medium enterprises that heavily rely on foreign donors and investors may come to a point where they need to transfer personal data belonging to their users, customers, or employees overseas. Many times, you transfer data across borders without you yourself even knowing it. For instance, only by using a Gmail account, you're already storing the personal data of your contacts on Google servers in a country far away. On the first steps you should undertake, therefore, is to map out your organization, what data you are transferring and where to. Are you using an online accounting platform that contains personal data on your employees and suppliers' contacts? Where is the data hosted? Do you have partners that help you process data, like credit scoring services? Where are they located? As Meshach mentioned, in Kenya, a data controller or data processor is allowed to transfer personal data to another country only where it has given proof to the data commissioner that the data will be transferred securely to a place with equal or stronger data protection laws as Kenya. However, there are also certain situations where data can be transferred without notifying the data commissioner, such as when it is in the public interest or in line with the performance of a contract. We will discuss this and more in this episode. To guide us through this discussion, we have our speakers, John and Simon, whom I am excited to introduce. So, John and Simon, kindly introduce yourself. John.
Thank you, Lemmy and Meshach. Happy to be here. My name is John Walubengo. I'm an ICT lecturer at Multimedia University, but I also consult in the data protection space, partly because I was privileged to sit on the Data Protection Task Force that put together the current Data Protection Act of 2019. Thank you.
Hi, everyone.
Sorry, go ahead, Simon.
Okay, thank you. Hi, everyone. I'm Simon Verschaeve. I am a data protection and technology lawyer based in Belgium. For almost 3 years now, I am a practicing lawyer at DLA Piper, which is an international law firm with offices across the world, including global data protection practice. And before I joined DLA Piper, I've been a legal researcher at Ghent University, which is a university in Belgium. Thank you for having me.
Thank you for the introductions. Looking forward to the discussion of the day. So, John, this is to you. Can you help us break down what is a cross-border data transfer? What does the law say about it? And as you do that, after you do that, secondly, why does the data commissioner want to be informed when we transfer data across borders?
Okay, thank you for the question. To explain the whole concept of cross-border data transfer, probably we need to look at practical examples in recent times. And what comes to mind is the 2017 general election, where we had a presidential petition by the opposition. And during that court proceedings, the Supreme Court judges wanted, access to election records. And one of the lawyers in the courtroom said, we can't access that data because it's based in France, and the French technical team are asleep. Of course, that was not necessarily a good explanation, but it shows the importance of having critical or strategic data within your territory. Another example for cross-border data transfer would be more economical in that if you're not keeping most of your data within territory, it means you're keeping it outside territory. And from an economic point of view, it means that you're building technical capacity for countries outside Kenya at the expense of the Kenyan technical teams who would have otherwise built their capacity to host the same. Why will the data commissioner be interested? I think the data commissioner, from a regulatory point of view, will be interested in cross-border data transfer because some SMEs may feel that the data privacy laws in Kenya are too restrictive. But if we can keep that data outside territory, then we can manipulate it in ways that the local territory or the local jurisdiction may not allow us to. So the data commissioner will want to be able to ensure that SMEs are not escaping local requirements of the law by exporting the data outside the territory. Thank you.
Thank you for your wonderful and great insights, John. So you mentioned a great point, especially on SMEs. I'd like you to dumb it down a bit further. So what does cross-border data transfer look like for an SME, and in simple terms?
Okay, the SMEs should first and foremost, like you mentioned at the beginning, do an extensive inventory of their data processes and data sets. So you do a data map. I think in GDPR, they call it a record of processing activities. But essentially, the SMEs should first do an inventory of what personal data sets do they have and where exactly is it seated. Is it on-prem, for example, which means it's within Kenya, or is it in the cloud? And once it's in the cloud, then the issues of cross-border data transfer kick in automatically. And there will be restrictions or conditions within which that data should continue sitting outside the territory. I think we'll drill down to those conditions as we go along. Thank you.
Thank you for that, John. So I'll turn to you, Simon, now. So some argue that the need for appropriate safeguards and cross-border data transfers and the requirement to notify the data commissioner mirror the concept of an adequacy decision in Europe. What do you think about this?
Well, in the European Union, the GDPR provides indeed that personal data can only be transferred to a data controller or a data processor outside the European Union when the level of data protection guaranteed by the GDPR is not undermined. So that is similar. And first, the GDPR provides that this condition can be satisfied where the European Commission has adopted an adequacy decision. In simple terms, this means that the European Commission will pre-assess the laws and the practices in the destination country and will put that country on a white list. If the country is not whitelisted or has not been granted an adequacy decision, there is also an alternative to base the transfer on appropriate safeguards. In simple terms, that means that you need to conclude, for example, a contract between the party exporting the data outside the European Union and the party that is in the destination country. And there are also several derogations that are possible, but these are less relevant in practice. So there are certainly similarities where the GDPR or with the GDPR, where Kenyan law requires appropriate safeguards to be in place for cross-border data transfers. However, in the EU, there is no notification obligation for cross-border data transfers to the supervisory authority. Thank you.
So still on that, John, so what are some of the situations that can allow for an entity to transfer personal data across borders without notifying the data commissioner?
Okay, thank you. There are different conditions when you could do that, transferring data outside territory without alerting the data commissioner. Some of it include transfer by necessity. In other words, life and death issues. For example, in the recent situation of COVID, the statistics about COVID, the details about the individuals who have suffered that particular disease, even within territory, the data subject or the citizen sort of loses their right to privacy because of higher public health good or public health necessities. So there are instances where the rule does not apply because of the greater good of humanity. So in such a case, you must, or the SME does not need to sort of get approval from the data commissioner to send data out. Then there's the issue of transfer by consent. So if your data subjects have sort of given consent, but again, there are conditions of this consent, it needs to be well informed and clear. The instances where legal practitioners seek consent by giving very many or big documentation that they know very well the user won't read, and at the end of which they just give consent. So consent need to be precise, brief, and to the point. And once you get that, then at least you're in a good position to transfer data out of territory. There's also the transfer on the basis of adequacy decision that was provided for in law, whereby the data commissioner on a regular basis would sort of publish a list of countries where she thinks that Kenyan data sets will be safe in terms of that remote country has similar laws or have privacy regulations that are of adequate or they provide the same protection as the law in Kenya. The last one on binding corporate rules, we didn't have that in explicitly in the mother law, but there are aspects that speak to that in terms of data processing agreements. So you sort of ensure that if you're sharing data outside Kenya, perhaps with affiliates in remote countries, then you must sign a contract with those affiliates that protect, or they have conditions that are very similar to what the Kenyan data privacy law provides for. So if you have any of these conditions in place, then it's possible that you can transfer your data out of Kenya. Thank you.
Thank you for that, John. Especially the point on the binding corporate rules, because I don't think a number of people quite understand it. So, like how you brought it out.
Okay.
So, over to you, Simon. It's interesting that the EU is very different from Kenya in the sense that GDPR covers the whole European bloc. So, what is the European experience in regulating transfers outside the EU? And how do companies deal with transfers to America, China, and the UK?
Well, on your first question, indeed, since we have the GDPR, there is a higher level of harmonization inside the EU. And the idea is there that by adopting the same rules in all these countries, a safe area can be created within which there is no need to retain transfer restrictions and where personal data can flow freely. However, outside that safe area, cross-border transfer restrictions are then needed to avoid that organizations just transfer their personal data to escape the protection of the GDPR. So the transfer rules also depart from a broader fundamental rights perspective, based on the fundamental rights view on data protection and privacy, and the idea that these rights should also apply regardless where the personal data are being processed. And then on your point for transfers to the US, well, transfers have been a hot topic in EU data protection for some years now, which shows that it's not that evident to uphold transfer restrictions with global effects, such as those of the GDPR, both from a political, economic, but also a practical business perspective. For the US, that country has been granted adequacy status by the European Commission, but the EU highest court, the Court of Justice, annulled that decision, as well as its successor. So it's in its most recent judgment, which we call the Schrems II decision of 2020, the Court of Justice not only annulled the US adequacy framework, but also clarified that when you rely on the alternative, being, for example, standard contractual clauses, that alone is not enough. You also need to perform an assessment of the laws and the practices of the third country, you yourself as an organization exporting those data, to see whether the laws of the third country, of the destination country, do not impinge on the effectiveness of that GDPR transfer tool, such as the standard contractual clauses. So that decision had an important impact on business, and not only related to transfers to the US, also, for example, to other non-adequate countries like China. It led to some extent to legal uncertainty, and also result in a requirement to perform what we now call transfer impact assessments, or TIAS, which puts a high compliance burden on private organizations. And on a last note, for transfers to the UK, there has been some discussion after Brexit, when the UK, the United Kingdom, left the EU. Eventually, the UK was granted an adequacy decision for now, because the UK legislation is still based on the GDPR, but it remains to be seen how that status will evolve once the UK government starts amending that legislation and may take a different approach than the GDPR.
Thanks for that, Simon. So now back to you, John. So what is the place of data processing agreements when it comes to data transfers? You mentioned it earlier, so I'd just like you to talk more about it.
Okay, thank you. The data processing agreements within the Kenyan law is basically a requirement for managing third parties. So if you are an SME and you subcontract some of the processing to an outsider, and in this case, the outsider could be even your security guards. They are down there on ground floor, recording visitors' personal data, and you've subcontracted them that role. So they are the ones collecting that data. They are the ones storing it. They are the ones protecting that data on your behalf. So the data processing agreement requirement is that the security firm is supposed to not only sign a commercial agreement with you, but also a data privacy related agreement. And that data privacy related agreement is what we call the data processing agreement. And it applies for all your third parties, whether they are located locally within the country or you've subcontracted somebody outside Kenya. So you could say that the data processing agreement is a subset of the cross-border transfer agenda, in that we can use the DPA or the data processing agreement to make sure that whoever is processing our data outside territory is actually following the Kenyan sort of practice and regulations. Finally, if I was just to compare with GDPR, with respect to binding corporate rules, you'll find that for the GDPR situation, the binding corporate rules would kick in where the European regulators feel that the remote territory is not adequate enough. So it doesn't meet the GDPR expectations, and yet it's important territory in terms of data flows. So I think from a GDPR perspective, they would give the entities in Europe an opportunity to continue engaging with entities outside Europe that don't have, the rigor that GDPR provides. In the Kenyan case, we have not sort of provided explicitly for corporate binding corporate rules, other than saying that the data commissioner will on a regular basis publish a list of countries that she feels are of adequate protection that is being provided in this territory. Thank you.
Thank you for that feedback comment, especially on data processing agreements in this day and age where there's a lot of globalization in terms of how businesses are carried out and transfer of data. So now on to you, Simon. What are some of the practical strategies that organizations and businesses in Europe use to comply with their obligations on cross-border data transfers? And secondly, what lessons can enterprises in Kenya learn from that?
Well, in terms of practical strategies, I would mention, first of all, as John already mentioned, organizations should map their transfers. Without a good view on your transfers, it's hard to define a strategy. Second, some organizations have been adopting data localization strategies by looking for alternative vendors to avoid that data are being transferred outside the EU and to avoid the compliance work. That said, while that can be a solution for certain types of transfers, many organizations found out that it's hard to find an alternative or even impossible. And in terms of cloud services, even considering the possibility that some cloud vendors offer of in EU storage, meaning that your data will be stored in data centers in the EU, is not always a solution, as also access to those data from outside the EU is considered as a transfer under in terms of GDPR, and the GDPR requirements for cross-border transfers would still continue to apply. So, and anyway, careful vendor selection is always a good starting point. And third, if it is established that your organization does transfer personal data and you have a methodology, and you have a good view on these transfers, then you need to select an appropriate TIA methodology. As I already explained, you need to do an assessment of the laws and practices in the third country. And to perform a TIA, you need to do that assessment of the laws and practices of the country of destination, but that's not an easy exercise, especially not for SMEs. You easily have transfers to several third countries, which would mean that you need to start assessing the local laws in all these countries and keep that assessment up to date. So in practice, for SMEs, that means that to perform a TIA, you need to procure a methodology that is available on the market to conduct such assessments. From a practical perspective, to give you one example from my own experience, at DLA Piper, we have developed a legal tech tool that allows organizations to select just the countries of destination that they need, and which then automatically preloads an extensive assessment for each non-adequate jurisdiction. And then, based on a scoring mechanism, the TIA can be performed in an easy, standardized, auditable way, providing assurance towards regulators, but also significantly reducing the compliance burden for you as an organization. And I assume that for Kenya, similar products might become available on your market.
Thank you for that, Simon. It's quite insightful. I think this discussion has come quite at a good time, especially because the Data Protection Act in Kenya is fairly new. And the issue of cross-border data transfers, as we have highlighted a few of the salient issues. So now, as we wrap this up, I'd like to invite final thoughts from John and Simon in that order. So over to you, John.
Okay, thank you, Lemmy. Just to conclude, the cross-border data transfer conversation for organizations or SMEs is actually not easy. I was advising a client who, after we did data mapping, we realized that some of their Kenyan personal data sets sit outside Kenya, and more so in a jurisdiction that we felt is not really compliant or doesn't provide adequate protection. So we made a decision to move the data set to Cape Town. Okay, this cloud provider had instances, a data center in Cape Town, which from my estimation, it's not yet published by the data commissioner, but we thought because Cape Town has a similar law, that will be a safer location to position our data. But upon data migration, we realized that some modules were not running from the Cape Town data center. So that presents a technical challenge. You may want to comply with the law, but you will run into some technical challenges or potential technical challenges when you make the migration. So eventually we had to migrate to a data center in Europe, and everything worked. The other point I want to share is that whereas there is this sort of patriotism for data sovereignty, one reason why people want to localize data and prohibit cross-border data transfer is to say Kenyan data stays in Kenya. There's a sense of patriotism there. But if you take this across 54 African countries, where each country wants to say Ugandan data stays in Uganda, Tanzanian data stays in Tanzania, Rwandan data stays in Tanzania, what you eventually create is what we call data silos. And for Kenyan companies that are operating in the East African region, they're going to incur a lot of costs trying to split data sets and have some of that data sitting in Kampala, part of it in Kigali, and another one in Dar es Salaam. From a practical, technical point of view, when you're deploying IT solutions, that are scattered technically in that manner, then it becomes an overhead. So as African region, it's important to learn from Europe, and the European law is technically the global standard in privacy issues. But we must also appreciate that Europe is one economic zone. Africa is not yet there. So if we adopt wholesale what Europe has for the economic zone and plant it in Africa, where we are sort of isolated economically and politically and legislative-wise, then we present very serious hurdles to SMEs. So that's my closing remarks. What do we do in order to make sure that the cross-border data transfer does not present a significant barrier to trade within Africa? Thank you.
Thank you. Thank you, John. That was quite brilliant. Over to you, Simon.
Thanks, John. That was really interesting. I think what I can add, well, in the end, it's as we just discussed, it's a topic that is still under constant evolution, and not only from an EU perspective, where we are at the moment awaiting a new adequacy decision for the US, which is already heavily debated. Also globally, we see that data transfer requirements are emerging. For example, in China, but also in Africa, as we just discussed. And that only adds to the challenge for organizations, especially when you are an SME and your compliance resources are limited. Thank you.
Thank you. Thank you, Simon.
Okay. Thank you, Lemmy. Thank you, John. Thank you, Simon, for such a brilliant exposition of the topic. So we've come to the end of our show. Thank you to our listeners who will be listening to it. So to stay updated on data protection laws and concerns in Kenya, be sure to follow the AU-EU D4D Hub through the coming weeks. The Data Protectors podcast, as I mentioned, is produced in collaboration between GIZ Kenya and Kictanet as part of the AU-EU D4D Hub project. Follow the AU-EU D4D Hub on social media. You can find us on Twitter at D4DHub_AU-EU. You can also contact us there for questions or comments. If you're listening to us on Anchor, you can leave a voice message as well. Don't forget that all the episodes of this series are available on D4D Access. D4D Access is an online platform powered by the AU-EU D4D Hub, which aims to promote exchanges of knowledge and expertise between African and European digital stakeholders. Feel free to visit the website at www.d4daccess.eu. Thank you so much for listening, and see you next time.